Welcome to today's program titled Time Well Spent Session 4, Arbitration of Wage and Hour Claims. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Kelly Kelker. Kelly, please go ahead.
Good afternoon, everyone, and thank you for joining us for the fourth session of our webinar series, Time Well Spent. For those of you joining us for the first time, I serve as General Editor of the Wage and Hour Class and Collective Action Treatise, primarily authored by Seyfarth attorneys under the leadership of Brett Bartlett, Noah Finkel, and Andrew Paley, who are wage hour partners in our Atlanta, Chicago, and Los Angeles offices, respectively. But today my role is to keep things moving along so that we can address all of the important legal developments in our 45-minute program on one of the hottest topics in the wage hour field, which is arbitration of wage hour claims. We're fortunate today to have with us three experienced attorneys in this field of law. First up will be Michael Steinberg, an associate in our Boston office and a member of our Wage and Hour Litigation Practice Group. Michael's practice focuses on issues faced by employers in industries such as hotel, lodging, and restaurants, which are all high turnover sectors that are often targets of class or collective actions in asserting wage hour claims, and that call into focus the importance of arbitration agreements. Michael will first address some of the foundational legal issues that employers should consider in deciding whether and how to implement an arbitration program, and later he will discuss recent court holdings about the issue of whether notice should be given to persons within a collective action, but who have executed arbitration agreements. Second up will be Daniel Wang from our Los Angeles office, who will tackle the considerable job of updating us on arbitration developments in under 15 minutes in California. Daniel frequently counsels employers on the best way to include class action waivers and arbitration agreements that will withstand the evolving legal attacks from the plaintiff's bar. Daniel defends clients in class and PAGA actions in California with a focus on the healthcare industry and cases involving joint employment issues. Finally, we'll hear from Patrick Bannon, a partner from our Boston office. I told the presenters that I wouldn't read their bios, but I did find this excerpt on Patrick's online bio that I thought was particularly descriptive of the way he approaches the practice of law. Quote, "While Patrick works in the world of courts and government agencies, his heart is with the people who try to run fair, productive organizations without being drained, derailed, or paralyzed by the legal system." End quote. About 4.5 years ago, Patrick helped 2 clients deal with mass arbitration campaigns, and since then it's been a major focus of his practice to help other companies avoid mass arbitration. Patrick will be presenting to us today on that topic. So without further ado, Michael, will you kick us off?
Absolutely, Kelly. Thanks a lot, and thanks everyone for listening. So if we go to the next slide here, the opening question that maybe is good to start with is, why is it time well spent for an employer to consider implementing or administering an arbitration program for its employee population in the first place? So on the next slide, we'll talk a little bit about the whys and the why nots. So why decide to implement an arbitration program? Well, first, arbitration proceedings are private, and I say parenthetically more confidential than actions in court. Of course, judicial proceedings are open to the public, and in the wage and hour space, where an employer is often hit with a lawsuit that implicates pay practices that involve a lot of potential claims by many employees, class and collective actions. When employees find out about, say, a publicly filed case, there can sometimes be this Me Too effect where suddenly more claims pop up. So having some degree of confidentiality is very helpful. I should note here that arbitrators ethically are generally bound to keep the proceedings confidential. That doesn't mean that parties necessarily are, so just keep that in mind. Nonetheless, privacy is an important consideration for employers. Second, arbitration really is all about party choice and autonomy, right? When structuring an arbitration program, an employer can select venue, can make favorable choice of law decisions, right? Say that may have a significant impact on the way that arbitration agreements and also the underlying claims will be adjudicated. Next, arbitration agreements can include, and we'll talk a little bit more about this in a moment, class and collective action waivers. That is, with some exceptions that Patrick is going to cover much later in the program, that can yield enormous benefits to avoid the potential class or collective action. Arbitrator selection. When employers are dealing with proceedings in court, there is really no control over the judge who is assigned to the case. That judge could have been a former prosecutor or criminal defense attorney with virtually no expertise in the complex area of wage and hour law or even employment law. But arbitration allows for some degree of control over selection, allowing the parties to enlist an arbitrator or draw an arbitrator who is experienced in wage and hour issues. And last, arbitration can be less expensive than judicial proceedings because they tend to be less formal, they tend to be more streamlined procedurally. Okay, so that all sounds great. Why not arbitration then? A few reasons. First of all, unlike the inexperienced trial judge who could be reversed on appeal, arbitrators' awards are generally confirmed as enforceable judgments, and there is virtually no way to appeal that. If the arbitrator engages in fraud or other serious misconduct, that may be a basis to vacate an arbitral award, but review of the facts and the law, that's not something that you're going to get in confirmation of an arbitration award. Arbitrators are also not really bound by precedent, this notion of stare decisis. So an employer is less able to predict what an arbitrator is going to do in any particular case. There's much more limited pretrial discovery and motion practice in arbitration proceedings. That can sometimes mean that the employer is not finding out as much about claims, especially if for some reason an employer does not have a class or collective action waiver and there are multiple employees at issue. The employer may be limited in some of that pre-hearing discovery that they may otherwise get. And as I noted in the third bullet point, dispositive motions are much less common in arbitration, and arbitrators have a somewhat perverse incentive, right, to deny dispositive motions, because if a case is dismissed before hearing, well, the arbitrator is not compensated for presiding over that hearing. So for that reason, a lot of arbitrations do proceed to a hearing, which is the equivalent of a trial in arbitration. All right, so turning to the next slide. The basics of arbitration agreements and their enforceability. So there is no federal employment statute like the FLSA that governs arbitrations. It's the Federal Arbitration Act and state arbitration acts that are going to govern the availability of arbitration, and the procedures that are applicable to arbitration. And believe it or not, for the entire 20th century, it was actually not a settled question of law whether the FAA even applied to employment claims at all. The Ninth Circuit created a circuit split when it said that Section 1 of the FAA actually excludes all employment contracts. Supreme Court fixed that in the Circuit City case, Circuit City versus Adams, or corrected that and held that the FAA does not apply to transportation workers, but it does generally apply otherwise to employment contracts, with some exceptions that aren't relevant here. And that core requirement of the FAA, that arbitration agreements have to be enforced on the same footing as any other contract under state law, that is something that's going to apply whether you're in state court or federal court. So moving to the second bullet point here, in addition to the question of whether employment agreements were even covered at all, there was also an ongoing debate over whether the National Labor Relations Act actually made class and collective action waivers and arbitration agreements unenforceable. The Supreme Court answered that question in the Epic Systems Court versus Lewis case and said, yes, they are enforceable. And so you can see here that we've really had this trend from 2001 all the way to the present of pretty consistent muscular enforcement of arbitration agreements and class action waivers. Now, ordinary contract issues still arise, right? Contract offenses that are generally applicable, and questions of formation. All right, next slide. Very quickly, just a little tantalizing question that we ask here. Is SCOTUS souring on arbitration? I mentioned that up until quite recently, the Supreme Court just really had been marching, strongly in the direction of, enforcement of arbitration agreements and rebuffing state attempts, especially California, which that's going to be our next topic. State law attempts to subvert the enforceability of arbitration agreements. There have been a few recent decisions here that we would call to your attention, in which the Supreme Court has said that an arbitration agreement could not, that a federal court could not compel an employee to arbitrate. The New Prime case, more recently the Saxon case, airplane cargo loaders, the Supreme Court said are a class of workers engaged in, the interstate commerce with respect to transportation industry exception. And most recently, the Supreme Court agreed to take cert in a case that may very well reverse the Second Circuit, which had found bakery delivery truck drivers were not transportation workers who fell within the exemption for those workers from the FAA. And with that, I'm going to turn it over to Daniel, who's going to be talking in less than 15 minutes about the California nuances in arbitration law recently.
Thank you, Michael. Next slide, please. Each of these slides can be, and they have been, a separate presentation on their own. So this certainly is not intended to be a comprehensive overview of the developments, but I just wanted to hit some of the most significant developments that have happened in recent years. Perhaps the most important has been arbitration agreements and the intersection with PAGA claims. Prior to the Supreme Court's decision in Viking River Cruises versus Mariana, the California Supreme Court had held that PAGA waivers are unenforceable. So PAGA waivers would be the PAGA version of a class action waiver where an employee would agree not to bring a PAGA representative action. The United States Supreme Court upheld the notion that PAGA waivers are unenforceable, but at the same time, it recognized that PAGA claims can be divided into two components. One is the individual PAGA claim, and then the second is the non-individual representative PAGA claim, which would seek penalties involving all other employees who may have been potentially aggrieved by violations committed by the employer. This concept was contrary to California law, and so the Supreme Court said that under the FAA, the PAGA claim must be divided into these two portions. And what the Supreme Court found was that the individual PAGA claim can be subject to arbitration, assuming that an arbitration agreement is broad enough to cover those claims. One outstanding issue, however, is that the United States Supreme Court found that once an individual PAGA claim is sent to arbitration, that plaintiff loses standing to pursue the representative portion of the PAGA claim, just as would happen in a class action. However, the Justice Sotomayor noted in her concurring opinion that that is a matter of pure state law and that the final word would be for the California Supreme Court. In Adolph versus Uber Technologies, the California Supreme Court, very unsurprisingly, found that the arbitration of the individual claim does not divest or automatically divest the employee of standing. The only way that the employee would lose standing is if in the individual arbitration, there was a finding that the employee had suffered no violation at all. Next slide, please. Now, some of the other peculiarities that have happened in California in recent years are several. I just want to note a couple of these developments in this slide. The first is AB 51, which had added Section 432.6 of the Labor Code and Section 12953 of the Government Code. And in short, AB 51 had enacted a law that said it is unlawful for an employer to require employees to sign arbitration agreements as a condition of employment. The Ninth Circuit subsequently found that the Federal Arbitration Act preempts AB 51. So as long as an employer is covered by by the FAA, then AB 51 would be preempted. But that is one development in recent years. The second is a couple of sections in the Code of Civil Procedure that were added that makes it provides very significant consequences for not paying arbitration fees within 30 days after the due date. What had happened was that there were a lot of cases that were being filed where the employer or the defendant or respondent in an arbitration were just not paying the fees in arbitration, and those were just indefinitely being held in abeyance. And so the California legislature stepped in and said that employers would no longer be able to have an end around the arbitration procedure and instead have to pay the arbitration fees, both the initial fees and the subsequent fees, within 30 days of the due date, or else there will be a waiver of the agreement itself. There are a couple of other consequences as well under these statutes, but that is perhaps the most significant. Lastly, the last one I just want to briefly address is a law that is going to come into effect in 2024. Until this law was, until SB 365 was enacted, if an employer had lost on a motion to compel arbitration and then appealed that to the Court of Appeal, there was an automatic stay of the proceedings in the trial court. SB 365 eliminates the automatic stay and leaves it within the discretion of the trial court. But that was a significant factor for a lot of clients in deciding whether to enact an arbitration agreement, was to have the ability to stay in action if a court were somehow to find that the arbitration agreement was not enforceable. Next slide, please. As Michael mentioned, there was the Saxon v. Southwest Airlines case regarding the transportation exemption, which found where the United States Supreme Court had found that cargo loaders for Southwest Airlines were transportation workers within Section 1 of the FAA and therefore were exempt from the FAA. Now, the transportation exemption is relevant for California because a lot of laws in California, which are very hostile to arbitration, have been preempted by the FAA. AB 51 is one example that we talked about on the prior slide. And if an employee is not covered by the FAA, then all of the bad cases and statutes that otherwise would be preempted by the FAA would now come into play. The most troubling thing is that the Ninth Circuit has been expanding the definition of transportation worker, whereas initially and prior to Saxon, the notion was that a transportation worker under Section 1 had to actually transport goods across state lines. Saxon said that that is not the case as long as there's a close enough nexus. The Ninth Circuit, in a series of decisions, and just an oral argument yesterday on a case as well, seems to be expanding the transportation exemption to apply to anyone that touches and moves goods that is in the stream of commerce, even if that is done purely intrastate. And so now the Ninth Circuit is seeking to expand who might be exempt from the FAA, which can potentially cause a lot of problems for employers when it comes to California exceptions. Next slide, please. And so if the FAA does not apply, I just wanted to highlight a couple of the more significant consequences of that. The first is that class action waivers will be much harder to enforce. There was a California Supreme Court decision, Gentry versus Superior Court, that set forth a multi-factor test to determine whether a class action waiver is enforceable or not. Needless to say that it's an uphill battle to establish that a class action waiver is enforceable in California if the Federal Arbitration Act does not apply. So one of the most beneficial aspects of an arbitration agreement is perhaps a class action waiver. And so falling under Section 1 exemption would be quite disastrous for in terms of the benefits of an arbitration agreement. The second is that Labor Code Section 229 actually states that claims for unpaid wages can proceed in court even if there is an arbitration agreement. Section 229 was found to be preempted by the Federal Arbitration Act. However, for those employees that aren't covered by the FAA, there would now be essentially a bar in the ability to arbitrate claims for unpaid wages. And so when dealing with a wage hour claim, the claims themselves may not even be subject to an arbitration agreement if the FAA does not apply. Third, as we had talked about in prior slide, AB 51 would no longer be preempted if the FAA does not apply, and therefore any mandatory arbitration agreements could be subject to penalties and in a potential PAGA action for a violation of AB 51. So for employers that are not covered by the FAA, those who might be transportation workers, those agreements would now have to be voluntary in order to make sure they do not run afoul of AB 51. Finally, the Viking River Cruises decision wouldn't even apply. The whole foundation of the Viking River Cruises decision was the application of the Federal Arbitration Act, and the Supreme Court held that the Federal Arbitration Act mandates that PAGA claims be split into individual and non-individual components. But if the FAA does not apply to an employer or to a class of employees, there would no longer be the right to arbitrate any PAGA claim, and there certainly wouldn't be this notion of an individual PAGA claim if the FAA does not apply. And California authority prior to the Viking River Cruises decision had held that since the state of California is the real party in interest in a PAGA action and the state has not agreed to an arbitration agreement, that an arbitration agreement cannot apply at all to a PAGA claim. And so all that precedent would now still be good law and not preempted by the FAA if a class of employees or the employer is not subject to the FAA. And with that, I'm going to hand this back to Michael, who will talk about notice issues in FLSA collective actions.
Michael, you're on mute.
Sorry about that, everyone. So we're going to zoom in on sort of a procedural issue related to arbitration that's unique to FLSA collective actions, which is the issuance of notice and how you handle potential opt-in plaintiffs who have arbitration agreements. So if we go to the next slide. So the anatomy of your typical FLSA collective action in most jurisdictions, although this is starting to change with new decisions out of the courts of appeals over the last few years. But in most places and until quite recently, in most jurisdictions, there's a two-step certification process. Step one, a plaintiff or a group of plaintiffs move for what's called conditional certification and issuance of notice by the court of an FLSA collective action to potential opt-in plaintiffs. In other words, hi there, we are notifying you that there's this court case, and then those potential opt-in plaintiffs could decide to join as plaintiffs. But what if some of those potential opt-in plaintiffs have executed arbitration agreements or otherwise agreed to arbitrate their claims? Should they be getting notice of a pending FLSA collective action? Well, pre-2019, there was sort of no appellate law on this, and the district courts were all over the map. So some district courts said that employees with arbitration agreements could not receive notice because, well, they don't belong in court. They agreed to arbitrate. Makes some sense, perhaps. Another sort of vein of case law was one in which courts were allowing notice to be issued to plaintiffs with arbitration agreements. And the idea behind it was that even if those employees have agreed to arbitrate, they have a right to receive notice of potential FLSA claims. And still other courts would also allow employees with arbitration agreements to receive notice of a lawsuit because, well, who knows, maybe the employee has some defense to enforcement of the arbitration agreement, or maybe the arbitration agreement will ultimately be found to be unenforceable. So no need to worry about that at the notice stage. Okay, so if we turn to the next slide. Circuit courts have now begun to address that issue. The district courts, as I said, were all over the place. And in 2019, there was sort of a big deal case. The Fifth Circuit was the first federal appellate court to weigh in on this question. And the Fifth Circuit was very clear that courts may, district courts may not send notice to employees who have valid arbitration agreements unless there is evidence that the agreement would not prohibit the employee from participating in the collective action. As to this question of, well, but don't the employees have a right to know, right, about the existence of the litigation? The Fifth Circuit was very skeptical of that, said that, that is essentially stirring up litigation, that the FLSA nowhere indicates that employees have some general right to know about potential claims under the FLSA. And the court also made two other important points, which is that where there's a dispute about the existence of an agreement to arbitrate, I spoke about this at the beginning, that issues of formation will often be litigated, right? Employer and employee disagree about whether they formed an agreement to arbitrate in the first place. Well, then the employer has the burden of proving the existence of a valid arbitration agreement by a preponderance of the evidence, and courts should allow the parties to submit evidence so that such a finding can be made. So that was the Fifth Circuit in 2019. Next year, the Seventh Circuit weighs in on the same question in the Bigger case. And, in sum, the holding in Bigger is similar to the J.P. Morgan case from the Fifth Circuit, but with a bit of a different emphasis. So instead of saying courts should not send notice to employees with valid arbitration agreements, Seventh Circuit said courts may authorize notice to employees with claimed arbitration agreements unless no plaintiff contests the existence of the arbitration agreement or its validity, or two, after some discovery, the employer establishes the existence of an arbitration agreement, again, by a preponderance of the evidence. The Seventh Circuit goes on to say in Bigger that courts may not authorize notice where an employer does show the existence of a valid arbitration agreement and, like the Fifth Circuit, instructed district courts to take evidence on the question. So what is the difference between Bigger and J.P. Morgan Chase, you may be wondering? Not a whole lot. Again, there's a difference in emphasis, but at the end of the day, both courts say if there's a valid agreement to arbitrate, then those employees with such valid agreements should not receive notice. On the next slide, So if we could turn to the next, there we go, the next slide. Most recently, we had a sort of couple years of no new developments in this area, but this year, in the Clark case, the Sixth Circuit again took up the question of whether notice should be issued to employees with arbitration agreements. And here, the Sixth Circuit took a different approach from the Fifth and Seventh Circuits. The Sixth Circuit, first of all, rejected the notion that at the notice stage, there should be some preponderance of the evidence, some basically factual finding by preponderance of the evidence with respect to the existence of valid arbitration agreements. The court instead said that evidence should be introduced regarding arbitration agreements and considered, but it's not dispositive, the question of arbitration. It should be considered along with all other evidence that generally would be considered by courts in determining whether or not notice should be issued to similarly situated employees. So this issue will continue to be, it's percolating in the courts of appeals, and it's an area where we expect continuing new developments in the law. And now I'm going to turn it over to Patrick so that he can have his turn to talk about mass arbitration, the flip side of what happens when employers implement class and collective action waivers.
Thank you, Michael. I'm going to talk about mass arbitration, specifically, what is it? Why is it a problem? Who needs to worry about it? And what are the solutions? Next slide, please. I sometimes describe mass arbitration as judo from the plaintiff's bar. And I don't know whether that's right or not, because I don't actually know very much about judo, but I have this vague impression that judo involves using an opponent's superior force to redirect the force, throw them off balance, and gain an advantage. And that is what the plaintiff's bar has done. The sophisticated members of the plaintiff's bar have started to do by using mass arbitration. They've been mostly unable to prevent employers from enforcing arbitration agreements writ large. Who's winning this game? Recently, employers have been winning with lots of decisions going in opposite directions. So some plaintiffs' lawyers have said, okay, well, we can't get class actions and collective actions very easily because of these arbitration agreements. So we'll do a different approach. Mass arbitration is in some ways similar to class actions and collective actions, but in the most fundamental way, it's the very opposite of it. Mass arbitration is when an individual person says, I would like to bring a claim against you for, let's say, a wage and hour issue. And gosh, I have an arbitration agreement, so I guess I should be filing an arbitration demand. So then the claimant does that. What makes it mass arbitration is that claimants do that in coordinated groups of hundreds or thousands or tens of thousands, in the non-employment consumer context, even hundreds of thousands. And what makes it new is that I think it has not been realistically possible for that to happen before, because each of these claimants is actually represented by just an ordinary attorney-client relationship, the plaintiff's lawyer. Each one has hired the plaintiff's lawyer as their lawyer. And so the innovation here is that the sophisticated plaintiff's lawyers, or some of them, have started using social media advertising and internet advertising to identify people who worked for an organization and might potentially have wage and hour claims against the organization. And I don't think anyone saw this coming until it started happening, or I guess the people who thought it up saw it coming, but nobody else did. Apparently, you can use social media to sign up tens of thousands of people, each of them as your client or more. And so what I've got on the screen here are examples that are kind of chilling. I mean, these pop up on people's phones, and they invite them to click on a button and answer a few questions, and then click, I'm hiring you as my lawyer. And now that's a client, and that's a person who can file an arbitration demand against your organization. So that's what the plaintiff's bar has been doing. They sometimes have phone banks staffed by paralegals to answer questions from their clients, because now they have tens of thousands of clients. but each one of those people is bringing the simplest kind of legal claim that's possible. I, claimant one, would like to bring a claim against you in arbitration for the wages that I say that you didn't pay me. So there's no representation, there's no like a named plaintiff representing some outside group. It's a one-on-one individual claim. Now that's what mass arbitration is. So next slide, please. Why is that a problem? And the simple answer is the cost. Most arbitration agreements do, and sometimes they must, provide that the employer is going to pay the lion's share, if not all, of the arbitration-specific fees and costs. JAMS and AAA, for example, if you want to use them, they require that the employer pay for all but a small portion of the initial filing fees. And to get your arbitration agreement enforced in many states, many employers have chosen to say, we'll pay all of the arbitrator compensation. That gets very expensive. If 1,000 people file arbitration demands against your organization on the same day, and let's say it's JAMS or AAA, order of magnitude, the initial filing fee, just the price of getting into the forum, is order of magnitude $2,000. Effectively, by filing those demands, the plaintiff's lawyer has inflicted $2 million of costs on your organization. There's no way to avoid those costs. You can complain that the mass arbitration campaign was unfair or a breach of the spirit of the arbitration agreement, or that the demands aren't really proper demands. You could try to argue that the claimants aren't really represented by the plaintiff's lawyer. There's no true attorney-client relationship there. The problem is you're howling into the wind. No one is listening to your objections. A court is not going to listen to your objections because you agreed to arbitrate. If you try to get a court to listen to your objections, the judge, if they're like some judges that didn't like this arbitration business in the first place, is going to, with great relish, remind you that this arbitration was all your idea. An arbitrator is not going to listen to your objections either unless you pay them first, and that's $2 million. So you are in a bind. And in California, to make matters worse, the legislature of California, piling on, has set a clock of 30 days. If you don't solve the problem within those 30 days, you're really in trouble. You start defaulting on the merits of the claims. You start having all kinds of even worse consequences that Daniel understands and I really don't. So that's why it's a problem. So hopefully everyone understands why it's a problem. It's maybe not quite checkmate, but it's awfully close to checkmate if you get 1,000 or 5,000 or 10,000 or 30,000 arbitration demands on a mass arbitration basis. You're going to effectively either have to pay extortion or pay a price that's worse than if you had paid the extortion to the plaintiff's lawyer. And these claims may have no merit. They may have no merit. They may be people who just say, oh yeah, I worked off the clock, just because they clicked on social media somewhere without a second's thought, and they're just unhappy with the organization and looking to strike back. But you still owe millions of dollars. So it's a big problem. So next slide, please. Who needs to worry about this? I mean, fortunately, there's very little good news in this part of the presentation, I'm sorry to say. But one piece of good news is that not everyone needs to worry. It's large organizations. In order for this to work, it has to be done at scale. So if you don't have thousands of people who work for you, then you're still potentially a target, but you're kind of like the person who is the second slowest, and you can, you won't get eaten by the lion because you've outrun someone who's slower and they'll get eaten by the lion. So you're not a high priority target in that case. But if you have thousands or tens of thousands of employees who are independent contractors, if you have a lot of turnover, so that number starts to get bigger with including former employees, and if you're in an industry with a workforce where you have a lot of people doing similar jobs, for example, retail, manufacturing, healthcare, hospitality, certain jobs in financial services, that makes you a higher value target. If you're a big name brand company with tens of thousands or hundreds of thousands of employees, this should certainly, mass arbitration is something you should certainly be thinking about. Hopefully you already have been thinking about it if you have an arbitration program, because you are potentially a target. one thing you can do is, we'll talk in a minute about looking at your arbitration agreement, but one thing you can do is have some expert who is, a true expert on social media, have them poke around and sort of do opposition research on yourself. You can sometimes find, just by doing a simple search, like name of company and unfair wage practices or unpaid overtime or wage claim, you can pull up plaintiffs' lawyers that are stalking you, and they're waiting till they can get the right number of people, if they can, and then they're just going to each file an arbitration demand or threaten to do so, and they're going to ask you for 7 figures to avoid that fate. And it'll be too late if you don't detect it ahead of time. So that's a little bit who can worry. And now solutions. We're cramming a lot into this program. So next slide, please. I will quickly add a slide that says we don't know for sure whether these are solutions. This phenomenon is new, and so our attempts to counteract the phenomenon are also new, and they're just starting to be tested by the courts. So if you put a term in your arbitration agreement to make mass arbitration harder or impossible, it might not work, and it might blow up the whole arbitration agreement. So we're lawyers, so we have to add caveats and stuff like that, but we don't really know whether this will work. So next slide. Here's what we are thinking might work if you're inclined to try it. And a lot depends on your culture, size of your workforce, where you're located. You really do want to think in your appetite for risk and what you think is likely to work. But here are some ideas that we've seen or we've tried or we think people might try. One idea, maybe my favorite, is arbitration. Came largely out of the labor context with unions. And almost any dispute in the union context ends up getting arbitrated. Typically in the union context, it's grievance and arbitration. First, there's a grievance filed, then there's sort of internal meetings, sometimes called conciliations. You can't just go straight to the arbitrator. You got to go through that process first. And that seems to be fair enough in the labor context. So the thought here is, why wouldn't that be a reasonable process to follow in the non-labor context? Make a provision in your agreement that first the person has to give you a written explanation of what their problem is and give you a chance to sit down with them. Maybe someone in HR sits down with them and talks to them about it and tries to resolve it. And it does 2 things. One, if someone has a valid but small value claim, you can avoid spending thousands in arbitration fees. You can just solve the claim. Another is, it's harder for a plaintiff's lawyer to just say, bing, click of a button, 7,000 arbitration demands just got filed against you, because each arbitration demand has to have a conciliation beforehand. We don't know for sure what courts will say. Some folks in California say that this is, they pejoratively call it a free peak provision, and they don't think California courts will like it, but who knows? It's an idea. A second idea is to require that your arbitration demands have some meat on the bones, not just to say, my name is John Smith, I worked for this company, and I was sometimes not paid overtime. If you require that a valid arbitration demand have meat on the bones, you might potentially make it harder for the plaintiff to do mass arbitration. You'd probably want to combine that with some kind of process that allowed you to somehow stop the duty to pay fees until it was determined whether an arbitration demand was valid or not. So there'd be some careful drafting there. Just going to fly through some of the rest of this. Some employers and some arbitration providers have special procedures for mass arbitration. One popular or semi-popular idea is to have bellwether cases, where someone files 1,000 demands and you stay 995 of them and you arbitrate 5, and then you wait and see what happens after that. It's not a perfect solution, because who knows what happens after that. You still have 995 in the wings, but maybe you can delay the fees for those 995 and at least get a chance to show that there's no merit to the claims before you end up owing millions of dollars. And tied to that is JAMS and AAA are the maybe the biggest, best known arbitration providers. There are others that are trying to make their name, and so they're potentially trying to be a little more innovative here about mass arbitration. One is FedArb, another is New Era, and there's a bunch of others that are willing to be a little bit more creative. You have to be careful though, if you feel like if someone thinks the arbitration provider is just in the pocket of the employer, that affects enforceability. So you want an arbitration provider with credibility, but it doesn't necessarily have to be JAMS or AAA. And You could give yourself the option to rescind if too many arbitration demands come in. Maybe you just get the option to say, forget it, we'll just litigate. Because a class action is sometimes better than mass arbitration if the fees are too high at the beginning. You can make the claimant pay some of the costs. You can say some claims, like off the clock wage and hour claims, aren't subject to arbitration, or small value claims aren't subject to arbitration. So we tried to cram maybe a little bit too much for 45 minutes, but I think that is time. And so I will stop there. And of course, we welcome questions afterwards or in the chat. Thank you.
Thank you, Patrick. You've given everyone so much to think about regarding their arbitration agreements. And thank you also, Daniel and Michael. And thank you everyone for attending today. The CLE code for today's program is SS, as in Seyfarth Shaw, 3131. So SS 3131. And on the screen, you'll see information about upcoming sessions of our Time Well Spent series. And the next one will take place in early January 2024, hard to believe. And as you can see, we'll discuss developing and defending exempt status classifications. So thank you again for joining us, and best wishes to everyone for a safe, happy, and healthy holiday season. Bye-bye.